important stuff. This is a big one right here. So what's the difference between a will and a trust? Well, if we have a will, does the will have to go to probate? Yes? Anyone say no? Anyone say it depends? It depends. Good. That's a good weasel lawyer answer, right? It depends. Well, you're right. Those of you that said yes, for the most part, you're right. Usually, a will means probate. Unless absolutely everything is joint, then you can avoid probate on the death of the first spouse. You still have to deal with it on the death of the survivor. But usually, unless everything is joint or it's a very small amount of money, you have to go through probate. Well, what's probate? Well, probate's a pain. Probate is all these nasty P's here. It's pricey, it's public, it's predatory, it postpones people's prosperity. Try saying that 3 times fast. And it's prone to challenge. Let me give you an example here. Okay, so again, we have a will and someone passes away. What happens? What's the first thing that happens? Well, we have an executor, right? The executor has to find the original will. It can't be a copy. Certified copy of the death certificate, a list of heirs, probate information form, probate tax form. By the way, the court likes this one because that's how it gets paid. Okay? So basically this whole process is public. Just like a real estate deed, you can go down to the courthouse if you have a mind and read somebody's will, see how people get their money, etc. Do people do that? Yeah, they do. They do that all the time. There are people making a living doing it and then contacting the survivors, selling them stuff, etc. But anyway, so you go down to the courthouse, you give them all these forms, you pay the fee, then you come back over here, they say, okay, we need an inventory. Say, okay, here's the inventory. We got a house, a bank account, broker account. Used to live in North Carolina. We still got $1,000 in an account down there in the bank in North Carolina. Uh-oh. That's going to be a problem because we can't probate that in Virginia. The executor's going to have to go to North Carolina for that one. But let's say we have all Virginia assets. We come over here, we do the accounting. Court says, thank you very much, collect the fee here. If there's more than a couple of assets, we're going to have back and forth here. We're going to have interim accountings. Then eventually we do a final accounting that the court accepts. We paid off all the creditors, everything balances to the penny, which it has to do. Then finally the commissioner says, okay, you can pay the money out to the beneficiaries. How long does this whole process take? 7 or 8 months typically before any of your heirs, before anybody sees a dime here, and that's if everyone gets along. So what happens, remember I said one of the forms here is a list of heirs. That's not just who's in your will, but that's anyone who could potentially inherit under Virginia law has to be listed here. So we have a cousin, they haven't spoken in 20 years, they're disgruntled. They decide, okay, we're going to do what? Contest the will. So the cousin, she goes out, she hires an attorney to contest the will. So now that person has an attorney. What does the estate have to do? Hire an attorney, right? Generally speaking, we say for every attorney involved, you can add about another 6 months to the process. So now, instead of 7, 8 months, now we're talking 18 months to 2 years. And so now we've got 2 attorneys involved, so what do you think's happening to this money over here? It's going to the lawyers, right? It's going to the probate attorneys, not to the people that we wanted it to go to. So that's the probate process, and you see how it does all those things. It's predatory, postpones people's prosperity, prone to challenge, etc. So that's the bad news.